Hello, everybody. It's James Donnelly coming to you with episode 18 of our welcome back. 18 times.
Happy to be here. Lucky 18.
Well, we must have a hot topic this week because we had over 600 people registered today, and I think I know why. I just want a couple of housekeeping items before we get going. First of all, I want to thank you for bringing Joe Connolly on our last episode. There was a lot of great feedback on public justice. A lot of our listeners didn't really know that much about it, so I think that was very educational. And all of our episodes are up on castlegroup.com. Just hit on the COVID banner and it'll take you there. And also, I know you're using it, but I'll repeat info@castlegroup.com between episodes. That's the best way to get any information that we talked about on here. And then two more quickies. If you're having any trouble with your login, just log off and log back on again. It's the best we can do for you. And then finally, we're going to have lots of Donna today because there's so much going on with phase 3. And as smart as she is, we can't let you walk away with that as legal advice. She's just sharing her brilliance, and we appreciate it. We have some polling questions today, and we're grateful for your participation in that. And really the main purpose of that, it helps Don and I a little bit, but more so your peers who are on the call get to know what each other are doing. So our plan for today was kind of like a town hall. We end each episode with so many unanswered questions that we thought, well, this week we'll just do kind of an open forum. And then phase 3 came along, and we really, as much as we're going to try and get to as many questions as we can, I think we'll do a kind of an open forum in a future episode because we're really going to be focused today on what this new phase means. And then we'll do a little update and then start answering questions. And I thought before we do an update, Donna, I'm going to get the poll question up one right away. I'd just like to know whether our communities are making changes to their COVID restrictions now. So Donna, since we last met, first of all, I would like to do my Texas update because we do have some listeners there, and I know, Donna, you're not a Texas attorney, but the Texas governor did extend their disaster status on September 7th, and he also issued a executive order on the 17th that continues, in fact, increases some restrictions. Texas is having some really bad case numbers out there, and
yeah,
unlike Florida, ours are knocking on wood down. So hopefully we can keep it that way.
I think we're stable. On that map I keep looking at, our numbers seem to be stable so far, which is a good thing.
Yeah, in fact, Mariness, can you bring up, several of you in your emailed in questions asked me, James, where do we go for data we can rely on? And I personally use a website called the Florida Scorecard, not just for COVID, it's for many things. Mariness has put it up there, it's floridascorecard.org. But if you go, first of all, go to all counties, Mariness, this is just Collier, but you can pick it, you probably just have to go back one level. So, in fact, Mariness, just click on the daily average new cases, you'll see 34.1. We just randomly picked Collier County. And if you click on that, you get all the data. By the way, this is data about everything that has to do with any of your counties. So this is a very reliable source of all things in whatever county you're in. So that's great, Mariness. We can, I just wanted to show people what depth, and you can keep drilling down into different levels of data. But I think the big news, Donna, first of all, emergency powers are still in place till November 3rd. Is that correct?
That's correct. Yeah.
And the evictions moratorium, interestingly, expires tomorrow. And I don't, as of press time here, I don't think we've had any indication whether that'll be extended on rents and mortgages. Are you aware, Donna?
I am getting the feeling that it's not going to be extended, but we never know until the last minute. So, stay tuned. But again, this only impacts bank foreclosures, not association foreclosures. And at least at our firm, we've been proceeding with foreclosures in the routine course of business. Fortunately, we have not seen an uptick in delinquencies and foreclosures so far. So not good. So far, so good.
In our experience on the management side, when we went into COVID, we anticipated some delinquency, and we've seen like a very minor change, and that's good for the communities and a testament to all our residents.
I think residents have gotten the message that if you're going to pay somebody, pay your association, okay? Because they can foreclose more quickly. And as we know, the banks have been stalled in their foreclosure. So hopefully, I think the residents, for the most part, have gotten the message that you really do need to pay your association dues.
It appears. Marinette, share the results for poll 1 with our audience. So this is just to give you a feel of what your peers are doing in their communities. Increasing restrictions, 5%, decreasing 28%, and no change 6%. Donna, that's probably what I would have expected to see. Probably the increasing ones, maybe they had an infection in those communities.
I agree.
Okay, and so I want to jump into phase 3, which is the big news, the big update. And Marinette, while we do that, why don't you put up question 2 before we start talking about phase 3? We know that you have been listening to the news on phase 3, and you may answer this question better after this episode.
Yeah, I'm very interested in the answer to this question, James. And maybe we should put it up again after I explain the order. What do you think?
Okay, well, let's do that, and why don't you start with what is this phase 3 all about, and what does it mean to us?
So the governor issued Executive Order 20-244 on the 25th, and here's the title of the order: Right to Work, Business Certainty, and Suspension of Fines. So I think the title says it all. This latest phase 3 order is designed to stimulate the economy in Florida. And basically it says that if there's any local government order that limits indoor dining in a restaurant to 50%. First of all, they cannot limit. No local government order right now in Florida can limit indoor dining that led to less than 50%. If there's any local government order that limits indoor dining to less than full capacity or 100%, that local government must prove that they are doing so in the interest of public health and safety, and they must quantify the economic impact. And the other portion of this phase 3 opening is a suspension of fines. And that is a suspension of fines that would be levied by local government for people who are out on their streets violating mask mandates or going into businesses violating mask mandates. This order is going to do almost nothing for the vast majority of associations, with the exception of mixed-use communities, James, that have commercial units that are conducting business, and perhaps the association has limited foot traffic in and out of those commercial units. Other than that, for purely private residential communities, which is the vast majority of our mutual client base, this has no impact.
Okay, you brought something up. I've got all my notes here, and I want to grab them while you bring them up. But several people have asked when DeSantis said no fines, and I'm a board member, and I know one of my remedies are fines. I'm thinking I can't fine, but just to be clear, this fining, it really is related to business establishments for mask usage and whatnot.
Correct. It's county fines.
County fine does not affect associations.
Does not affect the association's ability to continue to enforce their COVID protocols, either through fining, suspension of use rights, emergency injunctive relief, arbitration, mediation. You have all those remedies still at your disposal. The biggest ripple effect, other than having my phone ring off the hook and my inbox flooded with questions, is that you've got residents now that once again are going to their boards saying, it's over. The pandemic's over. Phase 3, we're open for business. Why is our hot tub still closed? Or why is our gym still closed if we can go eat indoors in a restaurant? That's the issue right now.
Well, I think you're right. And really, to me, the biggest takeaway today, because phase 3 has surprisingly little legal effect on our associations, is how do we manage the expectations of our residents and board members who read this and go, uh-oh, or they're excited. The reason that it doesn't impact us directly is the restrictions that we put in place have been done so under the auspices of our emergency powers. Is that correct?
That is correct. And this latest phase 3 order does not rescind the statewide state of emergency, which, as you just said at the outset, is in effect until November 3rd. So everything we've been talking about over the last 6 months since the statewide state of emergency was initially declared remains true. The issue that's coming up, and I'm sure you're hearing this too, James, is boards like the comfort of local government and state government sort of setting the framework here. Those are minimum standards. We've been saying that from the beginning. Just following minimum standards is not going to insulate your board from liability, and it's also probably not the right thing if you have a particularly vulnerable community with either active infections or a vulnerable population.
Yeah, so that does, though, bring up the question. So that gives me some comfort. I'm a board member. I'm okay with my current restrictions, maybe. And I have that till November 3rd. We talked just prior to coming on about possible options on November 4th, because clearly coronavirus isn't going to be over on the 4th. And my concern is, with DeSantis moving us to phase 3, that would indicate to me he's not going to keep emergency powers going forever. He may not extend them. So what do our boards do on November 4th if they don't have these emergency powers?
Yeah, it's a great question, and everybody is talking about this right now. It's important to understand that the emergency powers in chapters 718, 719, and 720, condo, co-op, HOA, the last paragraph in those powers says that the emergency powers are limited to a time that is reasonably necessary to protect the health and welfare of residents and invitees. So come November 4th, talk to your attorney. I will tell you the opinion I'm going to be giving my clients is I'm going to be looking at that language and discussing whether or not in their particular community it is reasonably necessary to continue enforcing those protocols. The emergency powers don't just disappear like that. It's when is it reasonably necessary? And let me give you an example, James. Remember, these emergency powers were created as a response to our storm season here in Florida. So think about this. Storm comes, storm damages the building. The next day, the emergency is not over. You now have weeks, perhaps, of repairs and renovations. You may have a week or more when the building is too unsafe for anybody to enter. And that's when the boards would use their emergency powers to say, your unit's off limits. So we have the framework already within which to operate, that emergencies don't stop just when somebody says they stop, okay? In your community, it may be a lot lengthier time period that you're grappling with this, particularly if you have an active infection or infections amongst your resident population or even amongst your staff.
Donna, I just realized I didn't share the last polling results. Mariness, please share. This is whether our boards, Donna, intend to change as a result of phase 3. And the I don't know is probably the most expected one for me, because I haven't figured it all out yet. I do know, Donna, that Palm Beach and other counties are issuing executive orders as we speak. I live in Fort Lauderdale, so I saw that this morning. How do these local ordinances interplay with phase 3, and are they applicable to our associations? And because I know I read briefly the Palm Beach one. We operate in so many counties, I can't know them all, but they basically said, other than social distancing and masks, kind of all restrictions are lifted. But it wasn't my understanding that would apply to an association. That's really to the businesses in general public. Is that correct?
Yeah, it is correct. But let me read from you Broward County orders. So the counties that have been hardest hit with COVID numbers, Miami-Dade, Palm Beach, Broward, they're understandably concerned about this phase 3 order. Okay, Broward County came out with language that said avoid the 3 C's: closed spaces, crowded places, close contact settings. Okay, they are still reinforcing facial coverings and social distancing. So boards can continue to take cues from local government. Closed spaces, crowded places, and close contact settings, I think we just described at annual membership meeting, right, James? So again,
I have that question for you. So yes.
phase 3 is going to mean different things to different people, but it is designed to stimulate the economy and businesses. Once again, unfortunately, our officials have not taken into account that there are millions of Floridians living in private residential communities that are governed by volunteer boards and management professionals, and we have not given them guidance. And a lot of our boards like the cover to say, we don't want to keep the hot tub closed. The county or the state's making us do this. And to the 44% who don't know, and even the 18% who said they are going to change as a result of this phase 3, I would urge you to consider that phase 3 is not your reason to throw open the floodgates and say, we're back in business because Governor DeSantis says we have to move to phase 3. That is not going to insulate you from liability and potentially personal liability if you are operating your common areas with a substandard duty of care.
Okay, so I think that what our boards are trying to figure out was, okay, so phase 3 doesn't apply. How do I decide what to do with our policies? And I wanted to talk a bit about kind of some fundamentals. And the fundamental one that should be driving all of our decisions is the health and safety of our residents and staff. And so I can't think of a situation in a closed environment, and obviously for HOAs, this is their amenities, and for a condo, it's a big part of their building. The mask usage, to me, seems like a requirement for safety. Social distancing seems like a requirement for safety. And then all the cleaning protocols that we put in place in all of these communities. These are 3 areas where I can't see taking our foot off these restrictions. What are your comments, Donna?
I couldn't agree more. I mean, we've got the head of the CDC who said that a facial mask is probably more important in safeguarding public health and safety than a vaccine at this point. So why would your association say we're going to do away with the facial covering requirement? You're going to look to different experts. You're going to look to the Department of Health, the Florida Department of Health. You're going to look to the CDC. You're going to look to the other the confirmed medical experts out there who are doling out advice. But you know what, James? The government standards are only the minimum. And I actually look at this as, in the aftermath of a hurricane. Again, I'm getting back to those emergency powers and why, the genesis for their implementation and their creation. What did you do? The board didn't just eyeball the building and say, it's not safe. Of course not. You get an engineer out there. You hire a professional to come out and say, this building's not safe for your owners to go back into. It's not really that different here, James. I can see in the coming months, boards have been hiring their own infectious disease specialists to say, okay, you've had X infections, or here are the numbers in your community. Here's what's happening in the surrounding areas. Here, let me help you create pretty much like a disaster plan, a COVID plan. I could see that happening. I don't know why there is somewhat the feeling that this is a different situation for boards when it comes to decision making. When it comes to the destruction in the aftermath of a storm, the board doesn't sit around and wait to see what the governor says or what the local county says. They roll up their sleeves. They hire the experts they need to hire to say, what do we need to do to keep our community safe? Who do we need to hire to dry out the building? Who do we need to hire to tarp? Who do we need to hire to tell us structurally if this building is going to not fall, not collapse? Why is it any different here? It's on the board to hire the correct professionals and make these tough decisions.
One of those resources and experts they should look to is their legal counsel. And I wanted to put up poll question 3, Mayor Ness, because we were curious as to how many of our boards have gone to their legal counsel as one of the experts to set policy. And Donna, while they're doing that, the one that's lighting up the chat room here most is mostly from Palm Beach County because of the executive order they did yesterday that basically takes most restrictions up, including pools and amenities and whatnot. So most of the questions are about what do we do in Palm Beach County, and I think it applies to everyone because every county at some point is going to do their own executive order. I think in principle, executive orders by states or counties don't necessarily dictate policy in the association. So an association could still have a more restrictive pool policy than the Palm Beach order, as an example, that just came out.
Absolutely. And we've had communities in different counties borrow from other counties. For instance, Broward County had the no guest usage at the pool. So we had counties, Lee Collier perhaps liked that, and they implemented that as part of their COVID protocols, even though Lee and Collier never had that restriction in their local ordinance. So again, the local government orders are the floor or minimum. In Palm Beach County, so your Palm Beach County is now loosening up when it comes to a lot of these protocols. What does that mean for your Palm Beach Association? Well, it may mean that you want to follow suit, but you're still going to have to be prepared to discuss if something were to happen, why you opened up while we're still under a statewide state of emergency until November 3rd. There's an ongoing pandemic and there's not yet a vaccine. So if you feel comfortable simply following suit and saying, well, the county opens, so we're going to open, you still got to answer those other 3 questions.
Well, and I think especially in Palm Beach, where we have a lot, at least council has a lot of 55 plus communities, which is a higher at risk. I would think seriously about being too liberal in opening up when you have an at-risk community. Okay, I want to share the results of the legal opinion. You like this, Donna, as an attorney? Looks like you guys are pretty popular advisors. I think if I put up property manager, I wouldn't get such a high rating, so good for you. So yeah, 67.
Well, we are their safety net. So that goes a long way towards explaining to your residents why you're taking the steps you're taking, because you've reached out for a legal opinion and you're following that legal opinion. So it is a safety net of sorts. If you are making these decisions without the benefit of anything other than watching the news and
Well, Donna has frozen on us. So what I wanted to look at here until she unfreezes is the question that you're having is, Donna, you back?
I'm back.
Lost you. I'm going to keep going. You were commenting on how important lawyers are, which doesn't surprise me. But you know what's happening here, Donna? First of all, in terms of that, what I'm happy I can see we have an incredible number of people logged on today. Obviously, Donna's not giving you specific legal advice for your community, but we're hoping this helps you form your thoughts about what policy should be, and it will help you know exactly what questions to ask your attorney. So I think you'll find this very helpful. But here's the situation that's coming across the chat room. Because our residents are reading phase 3, they're reading the county's executive orders, the residents are expecting a loosening of restrictions, and that may or may not be the right plan. So my biggest takeaway from a management perspective is we need to get out a communication to the residents ASAP. This is all about managing expectations. Right now, their expectations are open the floodgates, we can do whatever we want. And we know that that's not a good decision of the boards in most cases. So my suggestion is, number one, make a decision, meet as a board, come up with a new, if it's going to be a changing policy, get it communicated and why, and maybe even reference seeking the counsel that you did. And I saw that was a recommendation of someone in the chat saying, should we get a letter from our attorney and share it with the residents? And that's certainly an outlook.
That's certainly one option, but we're talking about sticking a square peg in a round hole here. The counties are framing their moves according to what's needed to stimulate their businesses and protect their economy, okay? What's framing your board's moves is protecting your private residential community. These are apples and oranges. On the one hand, we're dealing with the economy and business and commerce, and on the other hand, we're dealing with private residential communities. These are two different things. So you're right, and we said this at the outset, that your residents are likely to now have unreasonable expectations. Why is my hot tub still closed if I can go eat in a restaurant? Isn't it more likely that I'll get the COVID in the restaurant at full capacity than in the hot tub? Yes, maybe no. But here's the situation: in a private residential community, easier to sue than suing a county, okay? And no insurance and potential personal liability on the part of the directors. So this is a completely different framework than what the counties are operating under.
Yeah, so where I was going with this one, Donna, is I describe it as a continuum of restrictions. On one end being normal operation, and at the extreme other end, probably the most restrictions we had at the peak of the coronavirus. And we want to move down that continuum as we get back to normal. So my suggestion to our managers on a manager call this morning was, look, we need to communicate that phase 3 doesn't mean we have to change our policy, but it does change the expectations of our residents, and it is an opportunity to revisit what our policies are. So the communication could be something along the lines of, we know you've all heard about phase 3, we've consulted with management and law, and here's what we're going to do. And perhaps it's prudent at this time, as the numbers are coming down, to start the loosening process. So, outside areas are a classic example, and I see lots of questions on pools coming in here. But I think maybe this isn't a legal advice, this is a practical advice. If that communication is phase 3, here's what we're doing, here's why, and here's the new policy that's more liberal than the last one, that at least gives our residents a hope that they're on the path. And I would think outside spaces, tennis courts, pickleball, pools would be areas, Donna, where maybe that would be the best to start. Do you agree?
Absolutely. I think that to the extent that you can loop your residents into some of the decision making here, it's when you just say everything's closed and we don't know when it's ever going to open. I think that creates a heightened sense of anxiety amongst your residents. I think saying, look, here's what we're going to do right now. Here's what we're operating under state of emergency. Here's what's going to be open. Here's what's going to be closed. Here's what we anticipate in a month or two. Okay. You don't want to set it in stone. Obviously, this could be reversed if the numbers go in the wrong direction. But here's our hope. Let your residents know what you're trying to accomplish, assuming that the numbers cooperate with those plans. Does that make sense? It's when you don't have a plan and you're just, you're not communicative, now everything's ratcheted up. And that's the problem.
And just to reinforce that, and how custom it is to each community, if you have an infection outbreak in your community or your building, all bets are off. You're going to have to actually go back to more restrictive. And frankly, I would hope the residents would want to at that point because they don't want to get sick. But I can't emphasize it enough. It's so situational. Now, there's a lot of questions coming up across the chat, Donna, on guests. And can we restrict guests? And if, in fact, I think the Broward executive order even addressed guests. But what is the rule on guests? And if we allow guests, can we put restrictions on the number of guests in our communities?
Well, again, this is very community specific, James. I think guest restriction can become a real slippery slope, depending on if you're making subjective calls about which guests to allow. So if you are allowing people to have family members now and friends come visit, and you're not limiting that, but you're still saying no realtors or construction, I think you have a problem. I think you have to take a holistic view of how many people do we want coming in and out of here, okay? And you can't, if you've got the door wide open over here with friends and family, but you're closing it over here to some commercial activity, I think you're going to have a problem. Remember, you're tied to a reasonableness standard. And this gets back to, and we're going to talk about it, the board's rulemaking authority. Almost every set of documents allows the board to make rules regarding the common areas, but when it comes to making rules regarding the unit usage, sometimes that's a lot more restricted. Remember, right now we still have emergency powers in effect, so we can declare portions of the property off limits, including the units. But when those powers are no longer in effect, we have to engage in a whole different analysis. But to answer your question, most of my communities are now allowing friends and guests to visit. They're allowing limited construction crews to come in. They're allowing in-person realtors, showings of homes. They're still not allowing open houses. Again, we're still under emergency. They're allowing limited crews and maybe not a month-long renovation, but certain renovations. And again, this is a conversation each board needs to have with council, with the management professionals to say, what can we manage? What's manageable here? Do we have an elevator that we can direct these people to? Do we have somebody ensuring that they're wearing PPE when they come in and out?
It's incredible the number of questions. I'll just apologize in advance to the audience. I mean, they're going by here so quick. I'm having trouble keeping them all together. But a nice flow off of guests, and we've got some questions here, are gatherings. And I think here again, I mean, if you want to super spread this disease, you have large gatherings. You referenced it, I think, in the opening about crowding and close contact. I do think even if we do allow guests, we need to be very deliberate on gatherings. Comments, Donna?
I couldn't agree more. Again, when you're looking at potential liability, it's going to be, well, if somebody gets sick, where were you? Well, I didn't go to the store, I didn't go here, but I did go to my meeting. You do need to, again, set the standards. I will tell you, James, we're heading into, what are we heading into? Annual membership meeting season here. Most of my communities are still doing a Zoom meeting with perhaps a hybrid, like a physical location, where they say, only 10 persons are going to be permitted. Everybody else is going to watch online. Maybe if they're doing an election, perhaps they have that in person with a counting committee where it's captured on Zoom where everybody can watch it. But this is not the close contact and the crowded spaces. We still have to look to the CDC and the Department of Health, and perhaps even, as I said, our own infectious disease specialists to advise our boards as to what is safe and what's not, what's too risky.
What about monitoring? We're getting some questions coming in here, and if we do open our pools or other amenities, do we still have to monitor them?
So not with regard to the local orders, but as part of your COVID disaster plan, I would say absolutely. How can you refute? Put it this way, how could you refute a claim of negligence that's brought on behalf of a resident or an invitee or even a vendor that you were negligently operating your common areas, your pool, let's take for instance, in the midst of a pandemic? What are you going to do to refute that? Well, part of the refutation is, hey, we had a monitor there. They were showing, they saw who was there, they were enforcing social distancing. Here's the heightened sanitization that we were employing while the pool was open. If you haven't taken those steps as part of your COVID protocol, what is your refutation when somebody says you were negligently operating your pool? What's your answer? Well, we always operate, we had it the same hours and days as we always had. You have no defense at that point. You haven't done anything different to say we operated differently in the midst of a pandemic.
I've got a couple questions on the board here, Donna, about they're kind of sitting on both sides, our audience. One, because they're feeling the pressure to open, and another one, a line of questioning is about the lack of insurance on coronavirus. And in fact, some of our listeners are leaning towards more restrictive because they don't want to expose themselves to liability. And in previous episodes, we've talked about the lack of coverage, and I think this goes back to your business judgment rule. And I mean, just as a risk mitigator, I think I would be more conservative than liberal when it comes to this. And I think what our audience are looking for is some rationale and defense for a policy that's more restrictive to their residents, which is understandable. I would say the same thing.
James, I would just say quickly, I sat on my own board of directors for 2 years, longest 2 years of my life. I understand the pressures. And if you can open safely, then that's something that's an option. But again, safely does not mean operating the way you did back in January. The new safe is you have to have monitoring. You have to have heightened sanitization. We are in the midst of a pandemic. There's no, regardless of this order, phase 3 order, the virus is still here. We don't have a vaccine, and we're in the midst of flu season. And I am not a panicky type of person. I'm not, as you well know. But I understand the pressure. I've sat on a board, but I also understand the old adage, the old axiom, no good deed goes unpunished. So I understand the desire to want to make people happy, but just make sure it doesn't fall within the category of no good deed goes unpunished. There is no insurance for this typically, unless you have that gap coverage. And even then, the gap coverage only covers the legal fees, not any award or settlement.
You mentioned meetings and before we, monitoring. At the peak of the pandemic, local municipalities had very specific monitoring rules, and we had many discussions of whether it could be management or volunteers and whatnot. Those restrictions, for the most part, I believe, are all relieved, and it's now just our judgment. And so at that time, we had said, using technology and cameras and whatnot didn't meet the test of some of these executive orders. But now we don't have that. And I would think that cameras would be a great way to enhance our ability to monitor. Do you agree?
Again, yes, it's something. It is something that you can say, here are the steps we took. But let's say you had a security breach in your community, James, and subsequently somebody is the victim of a crime, and they're going to go back to the board and say, what steps did you take? Because there is some foreseeability from the prior incident to my incident. So if I said I put up a security camera, that's great. You know what's better? I hired a roving security guard. There's different levels of response to the problem. So security cameras for monitoring, pretty good. Maybe even better, physical monitor, reduced hours, reduced days. Do you see what I'm saying?
I do. In fact, I'm seeing some comments here that there are still some counties that have monitoring requirements. Obviously, I don't know if the law in all 67, but if that requirement is still there, then they have to follow it.
Right, you cannot fall under the floor. So this is where it goes back to your legal opinion from counsel. Ask your counsel. We've been monitoring these local ordinances in all 67 counties as they come and go. Clients will ask, what is still in effect? It's confusing. It's hard to keep up with all of this.
I know it is. And that goes back to the question that we posted, have you sought your legal advice? I also have some comments coming along here. How could you have liability if you can't really prove where coronavirus came from? And that's a fair comment, but I think the bigger point is you don't even want to get into litigation.
We talked about that early on, and we've got perhaps new people listening. So personal injury attorneys, they don't have to prove 100% causality. They have to be able to prove that your community was operating with a substandard duty of care. You were negligently operating those common areas. So they don't have to prove 100% that the person who went to the pool and then went back up to the unit made somebody else sick or himself or herself sick. They have to prove you were negligent. And that's a lot easier to do than you might imagine.
Okay, so you had brought up meetings, and it was in the context of gatherings, and we're right in budget season. We're right coming into annual meeting season. I can imagine all of our audience out there is going, what am I going to do? Am I going to have an in-person? In fact, I had an email question yesterday about, my community is 700 or 500 people, and they want to have an in-person meeting. I just shook to think about that, but our recommendation is still doing meetings virtually because of gatherings. But do we have the legal basis to still be able to have those meetings virtually after the 3rd?
Okay. First of all, check with counsel as to whether or not your local ordinance prohibits social gatherings above a certain number of people. because the 500 unit condo may be in a county that will not even permit that. And if they proceeded with that, they would be operating beneath the floor of the county ordinance, and they'd be in trouble. Assuming your county doesn't have that, you still need to look to CDC guidelines, which I believe, going back and forth, they still do have a cap on social gatherings.
Right.
Again, if you fall underneath that now, when we talk about, I just talked about negligence and how it's not that hard to prove. That's one of the main components is, hey, you were operating below what guidelines were out there in terms of this pandemic. Virtual meetings, we've actually drafted this for next year to make clear that virtual meetings are available. That would be the way to go right now, at least until November 3rd. So when those first notices go out in Florida, James, we're not putting a location. We're actually saying we don't know whether or not this is the first notice. We're going to do it by Zoom, or we're going to do it in person, or a hybrid. It's the second notice that needs to have that information. So talk to council.
Yeah, and I think, Donna, our experience has been we actually get dramatically higher participation if we do it virtually. So, I mean, it's not just a case of what you have done in the past. You do want your owners to participate in it, and virtual has really changed that. In fact, it kind of segues into another line of questioning I wanted to have. And before I do that, I'd like to put up question 4, Mayor Ness. One of the ways we can address just about everything we've talked about for 18 episodes is never before have our documents, our governing documents, been laid bare to their deficiencies. And I've put up a question there, Donna, whether our listeners are considering amending their documents, but not only have you talked extensively about this being a good idea, not just for COVID, for a whole bunch of reasons. A lot of communities haven't revisited their documents in years, but the nuance I wanted you to address is it's not like we have to wait. We could actually start doing that process right now. We've learned our lessons through this process. So talk to me briefly and our audience about what we should do and when. Should we be waiting until this thing's over before we amend documents?
No, listen, I've done 6 document rewrite projects since this pandemic started, about 1 a month. And those are, as you know, a complete overhaul of the documents. A lot of associations have these antiquated documents. I mean, some of them look like they were written on papyrus paper. Now is the time. I will tell you that the ones that are redoing the documents now are incorporating emergency powers. Let me tell you how useful this can be, James. If your community allows short-term rental activity, as many do, particularly in, let's say, Miami-Dade County, or even up in the Panhandle and areas where there's a lot of short-term rental activity, we are amending those sections to say that the board can hit pause on that activity in the event of a medical crisis. That's been lifted, like Miami-Dade's ordinance right now. Once upon a time, it said no short-term rental activity. That restriction has since been lifted. But again, in your community, let's say you have an elderly population and you also have short-term rentals that are permitted under your documents, that is a conflict right there between those two things. Elderly population, short-term rental activity. We also have a lot of out-of-state owners, a lot of people who are still in Canada are not coming down, not because the border's still closed, I believe, and they're looking to rent out their units. So this becomes where we would want to amend those documents and say, maybe we should be able to hit pause on that kind of activity. Without that language in your documents, you have a problem, perhaps not with the emergency powers still in place, but certainly after the fact, you're going to have a problem saying we're going to make a rule that you can't short-term rent right now when it's in your documents that you can. So that's why it's so important to amend these documents to incorporate some of the lessons we've learned over the last 6 months.
Well, let's share our results, see what our audience thinks, Donna. We have 23% saying yes, they're considering it, 30% no, and 46% I don't know, although now that they've listened to you, I think that number is going to go down. And obviously there's a cost involved, right? A lot of our communities are experiencing the cost of COVID, and It's not like there's a bunch of extra money. But I do think that it's an opportunity that's staring us right in the face to make our ability to manage under these circumstances much more easier for the board.
Do you know what I find sometimes when I go into these document rewrite projects, James? Actual language in the articles or bylaws that places an affirmative duty on the board to protect the health, safety, and welfare of the residents. If you're listening to this webinar and you haven't asked council what your duties are under the articles and bylaws as a board of directors, I'm guessing people are scribbling this down and we'll be contacting council when we finish here. But you need to know that, because that ups the ante entirely. And there are a lot of governing documents out there that do place an affirmative duty on the board to protect the health, safety, and welfare of the residents, which is tough in ordinary times, but extraordinarily tough in the midst of a pandemic. That heightens everything.
Donna, we have a very specific question, but I think a lot of people are asking it, and I know we talked about it in general, but it's November 4th. I'm having a meeting. Can I have that meeting virtually?
I would say yes. Remember, this is for the time reasonably necessary to protect the health, safety, and welfare of your residents and invitees.
Now
November 4th, unless we have a vaccine or COVID has vanished, if you still have indicators in your community that cause you concern that somebody could potentially become ill as a result of attending an in-person meeting, then speak with council and see if you have the necessary tools to say, we're going to have this virtually.
Now, Donna, the statute you referenced, I believe, is for condominiums. That's not necessarily relevant to HOAs.
No, the language is, the emergency language is found in all three statutes, James.
Okay, that's why you're here, and I'm just modest. Okay, I wanted to, you had brought up a case that I think is relevant to this whole discussion, the Beechwood case, and I think our audience would be interested in what the case was about and what the implications are for us.
Yeah, the Beechwood Villas case was a fourth DCA case. It pertained to rental restrictions and guest occupancy. The lower court said that the association did not have the authority to pass those restrictions. The appellate court reversed and said that they did. And basically the litmus test was that the rules that were passed were not in conflict with anything else in the declaration or with the statute. So in that case, the board wanted to pass some reasonable restrictions regarding who was renting units and who was occupying units. The owner didn't like it, sued, and actually lost that case. And so that is one of the seminal cases when we look to the scope of the board's rulemaking authority. Typically, as I said at the outset, boards have pretty broad authority when it comes to the common areas. So I feel pretty comfortable that even moving on into December and January, that boards, again, this is going to require a legal opinion and looking through your individual governing documents, but most boards are going to have the ability to say, we're going to limit the hours for the pool or the gym or all the other amenities, because they most have very broad rulemaking authority when it comes to the common elements. Now, when it pertains to the use of the units, okay, that's a different story. And a lot of times they don't have such broad authority.
Interesting. Very interesting. I wanted to talk, Donna, about the physical plant, or actually more under the concept of the things that we should probably make permanent. So there have been some lessons learned, and some of these things like cleaning protocols and changing the physical layout of our community. And I'll use some examples. Right now we have some products that we've researched to make sure doors open automatically, so you don't have to touch all the surfaces so often. There's also some emerging science about different ways to enhance our air circulation systems. And those enhancements are beyond the scope of this discussion right now, but does it put any pressure or obligation on the board to in fact implement some of these permanent changes because of COVID?
I mean, I think if your board is not engaging as part of your long-term strategic planning when you're considering like a lobby renovation, let's take that. And I've got a couple clients right now that have pending membership votes related to material alterations. You know what? The touchless doors, the touchless surfaces, they are looking to redo the entire lobby. A lot of these clients. Why not think about this? This, I hate to say it, but this may not be the last pandemic we suffer. Even something as simple as the furniture you're purchasing and the grouping of it, the way you lay it out, the traffic flow in and out of your building, which can be done in a more reasonable fashion in terms of enforcing distancing. I think this is the new norm. We've talked about that a lot, James, the new norm. You may no longer want the sofas. You may want groupings of individual chairs in your lobby where you can just space them apart. Not much you can do with a sofa. So you have to think long term that, yeah, we are operating under a new norm. And why waste money on something not looking forward? We did this when it came to retrofitting buildings, high rises with sprinklers, right? If you're going to do it anyhow, you know you're going to have to do the sprinklers. Start thinking about that. It's really no different here.
Donna, first of all, Marinette, let's put up the last poll question just because I'll forget. And it has to do with November 3rd, even though we think there are some provisions in the statutes that may help us beyond that date, I think it's a good thing right now for our boards to be thinking beyond November 3rd. And so the question that we've got up there is, have we thought our existing plan, adjustments for phase 3, and then what's beyond that? Donna, but while they're answering, short-term rentals, vacation rentals, a lot of our communities do allow, outside of COVID, those, and I believe phase 3 is now allowing those again. So what's your thoughts on vacation and short-term rentals, and is there anything a community can do to restrict them now that they're allowed?
Well, there's a reason. There's a difference between a reasonable short-term rental program and an unfettered one. Okay, and even Miami-Dade, they're allowing short-term rentals, James, but they are limiting the occupancy. So the days of having 7 college kids come in as part of a short-term rental should be over. So again, speak to council and say, yeah, I talked about the fact that it's going to be really hard outside the scope of an emergency power to limit something that your documents permit. Okay, your documents permit short-term rentals. We're not exercising our emergency power. We would need an amendment to do away with it or rein that in. But I do think it's reasonable to say, to implement a policy, we want to know ahead of time who's coming. We want to know how many people. We want them registered. You may even want, depending on where they're coming from, you may even want COVID test results. There's any number of things you could do to frame it in terms of short-term rental activity in the midst of a pandemic.
Excellent. Okay, I wanted to share the results of the poll 5, and this, I don't think is surprising. We're literally trying to work week to week, month to month. The facts are changing so quickly. But it's funny, one of the questions that's come out of the poll is, well, what should our policy be after November 3rd? And I think the big takeaway that I wasn't aware of before yesterday's conversation, Donna, is all of our communities are listening, have an option after November 3rd using some specific statutes. And but we would not want you to go and do that without contacting your council. And Donna, we can share those.
It's not unlimited. Yeah, emergency powers, James, are not unlimited. It's a time reasonably necessary to protect the health and safety. By the way, I just had to say, I feel like I'm looking at somebody who's playing tennis against a ball machine that's gone crazy. You're doing a great job.
I apologize for that, but our audience is active today.
Yeah.
Good. Okay, so we're just have a couple of minutes left. I want to kind of walk through what I think I heard. And number one takeaway for me is that phase 3 direct impact on our communities is, it may be directional, but it's not mandatory, but it does create a time, Donna, for us to rethink. The numbers are coming down. 2, safety is the number one thing, and any thought of reducing mask or social distancing or cleaning protocols seems to me to not be good business judgment, because we could be right back where we started again. And then the other one I've written down here is fines. There was a big, the governor was very specific about no fines, but again, that does not apply to our associations, correct, Donna?
No, it does not.
And then, but the big one I think above all else isn't really legal, sorry, Donna, but it's, we need right now to get a well thought out, legally vetted communication to our residents to manage their expectations, because right now they've read the news and they think that we should be opening everything, and for a lot of our communities that's not the best decision, and the best way to manage expectations is communication. But I think you may need a little more meat behind this communication, referencing or attaching some legal advice. Donna, you agree?
I do agree. I mean, listen, James, I would just say this. If you've been sitting on your board for 10 weeks or 10 years, you know, in either case, that you're not going to make everybody happy. And I understand that it's great when you can say to your residents, this isn't us, this is somebody else that's making us do it. But you agreed to serve on a board, and it's a tough job. As I said, I did it for 2 years and it was enough. It's a tough job. Just as many people who want you to do certain things, there's other people who appreciate boards who are making the tough decisions, okay? And we're not out of the woods yet. Phase 3 is welcome news if you want to go to a restaurant or you are a restaurant owner or business owner. I come from a family of business owners. I get it, and I appreciate that relief for our business owners in Florida. But this does not make a difference when you are on a board running a residential private community. Everything we've been talking about the last 6 months still holds true.
Excellent. You had mentioned the 3 C's at the beginning, and a couple of questions in as to what those were again. I think they resonated.
That was a Broward County order that said, in light of this, because counties are scrambling now because they're having the same problems our boards are having, which is their residents now have, their citizens now have unreasonable expectations. So all these counties are putting out their own messaging. But Broward County order said, avoid the 3 C's: closed spaces, crowded places, close contact settings. So what is a close contact setting? You know, I can't think of any closer one than your condo elevator in your high rise, okay? This is not the time to say, you know, you don't need a mask to walk down a crowded hallway or get into an elevator.
You know what, it's one of the, I live in a high rise, and we have a rule, you have to wear your mask in maximum 4 to an elevator, and I'm sorry, I'm a resident, I want that rule. I don't want to be getting, in fact, I wouldn't get into a packed elevator, but to me, Donna, that's a perfect example of a reasonable rule that looks for the safety of our residents, which is the most paramount thing of all we've talked about today. Okay, wow, that was fast and furious, Donna. We've run out of time. I just wanted to tell our audience that, number one, if you have any questions, shoot them into info@cascrew.com. 2, in 2 weeks on the 14th, we're gonna have Florida's condominium ombudsman as our guest. So that'll be interesting. And 3, we also, though, have allocated some time because we didn't get to all the questions today, and there will be some follow-up nuances, I'm sure, about the phase 3 implementation. So we'll probably spend half of our next episode on talking to the ombudsman and half trying to get more clarity for our boards. But the big takeaway is safety of our residents, and make sure before you issue the next communication, get some legal advice. And then finally, I think it's absolutely necessary we get something out to the residents immediately to communicate what we're doing, why, and really manage their expectations. So, Donna, thanks for racing with me today.
My pleasure. It was breakneck speed today.
Yeah, and audiences, our audience, thank you so much for leading. We're grateful, and I know the residents are grateful. They may not always express that to you, but in the end, they are. So thanks for all you do, and we'll see you